Right, good afternoon, everybody. My name is Andrew Schaefer from Trafalgar. I'm based in Trafalgar's Johannesburg office in Birdhaven near Melrose. It's 5 o'clock, so we'll kick off. Welcome. Thank you for everyone giving up time to join us this evening on one of our further training webinars. Firstly, just to welcome our special guest, Jennifer Paddock, a friend of Trafalgar's. Welcome, Jennifer. Thanks very much for the time and joining us as an industry expert. Jennifer probably needs no introduction to those that are involved with sectional title and community schemes in South Africa. But just for the record, Jennifer is a specialist community scheme law attorney, dual qualified in both South Africa as well as Australia. She has 20 years of experience in the field and is the founder of Jennifer Paddock and Associates, a firm dedicated to providing legal advisory and training services to the community scheme industry in South Africa. So thanks again, Jennifer. Also joining tonight, left to right, we have my colleague Karine Coetzee, Trafalgar's National Property Manager based in our Cape Town branch, and Peter Menon, my colleague, Trafalgar's Director, Head of Legal and Marketing. Welcome and thanks all for attending. Just a few points of housekeeping. We are recording the session, which hopefully will be fine with all the attendees. We do that for, training purposes. This recording will be loaded on our training website, which is training.trafalgar.co.za. We have a host of relevant topics and frequently asked questions up on the training site, and it's really there for reference purposes for anyone to get free commentary and advice on frequently asked questions. So just to be aware of that. At the end of the webinar, which will end promptly by 6 o'clock, there will be a short survey pop-up. If you would like to, we would appreciate your comments on how you found the webinar. Also, any suggestions to improve the presentation of these webinars, and in particular, any topics that you would like us to cover going ahead. And we do try and run these training webinars monthly from February to November each year. And that will be our intention, is to cover important topics in the industry. Please do write any questions you might have through the webinar in the Q&A. Karine and myself will endeavor to answer some in writing. If there are recurring questions, we will group those and pose those to Jennifer just to answer, in person for emphasis and for clarity as well. So, if we could just let Jennifer get through a presentation of what's to come on the topic of who pays in sectional title, and then, we'll get to 20 to 30 minutes of question and answers at the end of the presentation. No need to ask for the recording to be circulated. Karine will organize for all those that registered to be sent a YouTube link of the recording just for your own records. If you would like it, if you don't like it, just delete that email. But as I said, it will be uploaded both on Trafalgar's YouTube channel as well as on our training website. With that introduction in mind, Jennifer, thank you very much. We're going to hand over to you, and we look forward to your presentation. Thank you.
Thank you so much, Andrew, for having me again. And yeah, always a pleasure to be here and hopefully bring some understanding to some of these more difficult, areas in sectional title management. So today, obviously, we're talking about who pays in sectional title, and there are many different things that we're going to deal with today, because this can be a massive area of confusion amongst not only owners, trustees, managing agents, anyone involved in sectional title. So I wanted to start with a foundational concept, which I think, Karine, we might need to go back one slide possibly, which is that, okay, no, don't worry about it, it's all good. Basically, when we're determining financial responsibility in sectional title schemes, especially when it comes to maintenance and repairs, we need to look at the nature of the property to determine who pays for it under the Sectional Title Schemes Management Act. So in sectional title schemes, property is divided into two main categories. We have sections and common property. Now, sections are the areas in the scheme that are individually owned by the section owners, and these are apartments or townhouses in a residential scheme. They are the offices in a commercial scheme, the shops in a retail scheme, and the warehouses in an industrial scheme. And then we also have common property. So we've got sections, which are the individually owned areas, and then we've got common property, which is the rest of the scheme, which is collectively owned by all the section owners. And common property can be divided into two subcategories. One, which we call unregulated common property, and these are the areas of common property that are not subject to exclusive use rights. They are, the perimeter fences, the main driveway, the foyers, the lifts, the passages, the outer skin of the building, the roofs, the foundations. And then we also have common property that is subject to exclusive use rights, and these are known as exclusive use areas. And these are specific areas of common property that have been reserved either through registration and shown on the sectional plan or through the scheme rules and shown on a layout plan attached to the scheme rules for the use of one or more sections. So they are generally private garden areas, balconies, and parking bays. And depending on what kind of property we're dealing with, it will determine who's actually responsible for it financially under the legislation. So if we can move to the next slide, please. How do we know if an area of the scheme is actually part of a section, or if it's part of the unregulated common property, or if it's part of an exclusive use area? This is where boundaries are incredibly important. And boundaries will help us to determine which area or which category of property we're dealing with. Is it part of a section? Is it part of the unregulated common property or part of an exclusive use area? So let's start with sections. Sections are owned to the median line, which is the midpoint of its floors, walls, and ceilings. And as you can see in this diagram here, the dotted lines show that midpoint of the walls and the floors and the ceilings. So any area of the scheme that is not within a section's boundaries is common property, but it may be one of the two types of common property. It may be unregulated common property, for example, that outer skin of the building, as you can see, that little area, outside of the section boundaries, the outer walls, or it may be part of an exclusive use area. And exclusive use areas, as I said, may be shown on the scheme sectional plan. We have two types of exclusive use areas. So the registered exclusive use areas will be shown on the sectional plan, and you'll be able to see the boundaries on the sectional plan. Or there may be a rule-based exclusive use area, which will be shown on a layout plan attached to the scheme's rules. So ultimately, if we can move to the next slide, please, to determine what areas of the scheme fall into each of these categories. Can we move to the next slide, please, Karine? Thank you. We must refer to, sorry, one back. I'm sorry, we're like in a bit of a delay here. So we need to look at both the sectional plan and we need to look at the body corporate rules to determine the legal nature of the areas in the scheme. These two sets of documents will show us the legal nature of the property and the boundaries of the different areas, and that will help to guide us when it comes to determining financial responsibility in sectional title schemes. All right, next slide, please. So once you've determined the nature of the property, then we can move to the Sectional Title Schemes Management Act, which is our main piece of legislation guiding management of sectional title schemes in South Africa. And this act includes a set of prescribed management and conduct rules set out in the regulations to that act. And the Sectional Titles Act and those prescribed management and conduct rules give us all the default financial responsibilities in a sectional title scheme. It tells us who is responsible for what, and I'm going to explain all of that in detail. But what I need you to understand, and this is very important, next slide, please, Karine. The default responsibilities that are set out in the legislation can actually be changed by a scheme's rules. So it's essential to always check the specific scheme's rules, because if they've been amended, the default positions in the law might not apply. Okay, so that's what you need to know. First of all, we have default legal financial responsibilities, but if the scheme changes its rules, we might have a different situation. All right, so let's move on to, with that foundational understanding in place, the meaty part of the webinar, which is who pays. And we're going to start with some of the common items. So if we can move to the next slide, please. We've got levies and special levies. As you know, if you are, involved in a sectional title scheme, which is why you're here, levies are the lifeblood of a scheme, and you're going to be dealing with these on a monthly basis. So section owners must pay their ordinary admin and reserve fund levies, as well as any special levies that are raised by the trustees. This is the section owner's responsibility, okay? And these levies are based generally on participation quotas. And that is the general default position, but there may also be Section 11.2 rules in place. So if a body corporate has created such a rule, or the developer has imposed a rule at the beginning of the scheme, there may be different ways of collecting contributions from owners. But the default position is PQ. Now, when a unit is sold, the seller will pay all the ordinary and special levy installments up to the date of transfer, but then the buyer becomes liable for all levy installments from the date of transfer onwards. And I just wanted to share a question with you that I got recently on Paddocks Club, which is our membership platform where we give fast legal advice and affordable advice on sectional title issues. And the question was, does a new owner become liable to pay levies on the date of transfer of the property into their name or the day after? So say, for example, the date of transfer is the 11th of April. Would the new owner then become liable for levies from the 11th of April onwards? Or does it include the 11th of April? Like, how does this work according to the legislation? And so the answer to this is that Section 3.2 of the SDSM Act provides that the new owner becomes liable for levies from the date of registration of transfer. So if the transfer date is the 11th of April, the new owner would be responsible for levies from the 11th of April, including the 11th of April onwards. So the outgoing owner will pay up to the date of transfer, and then the new owner will pay from the date of transfer, including the date of transfer moving forward. All right, if we can move to the next slide, please. Let's now look at exclusive use area contributions. So these are often called exclusive use levies in practice, but essentially the section owner who holds the right to use the exclusive use area is responsible to pay the body corporate for its costs incurred in maintaining that area. So remember, an exclusive use area is still an area of common property, and under the SDSM Act, the body corporate maintains the common property. So the body corporate is liable to maintain it, but the body corporate is obliged to recover the costs associated with that exclusive use area from the person who holds that exclusive use right. Now, this is where we need to again check the individual scheme's rules, because many schemes have rules that make section owners directly responsible for maintaining the exclusive use areas. So if that's the case, then that individual section owner is going to be repairing and maintaining the exclusive use area at their own cost. They're going to be dealing directly with their service providers, and there's no need for the body corporate to recover an exclusive use contribution from that owner because they're already directly responsible with it. So the default position is body corporate maintains and recovers the costs through an additional charge, which is an exclusive use area contribution. But many schemes have imposed a rule that the owners who have exclusive use areas must actually deal with all of that themselves. And in that case, then the body corporate sort of takes a step back and the owner is fully responsible for arranging and paying for the maintenance. So important to check the scheme's rules there. I wanted to just share another Paddocks Club question around this. So a trustee wrote to me and said, in our scheme, there's an owner with an exclusive use area carport, and the tarring under the carport is in need of maintenance. It needs to be resurfaced. There's roots that need to be removed and the area needs to be retarred. And the cost is in the region of 20,000 Rand. The body corporate hasn't raised separate exclusive use area levies or contributions to maintain the exclusive use areas. And my question is, who is now responsible for the costs of this resurfacing and the retarring under the carport, which is obviously on an owner's exclusive use area? And essentially, the default position under the Act is that the body corporate must arrange the maintenance and repairs of that area, but the exclusive use right holder is responsible to pay for it. So ideally, and I'm sure Trafalgar does this, the body corporate is proactively collecting exclusive use area contributions on a monthly basis from the relevant owners. And then those funds are kept for the specific purpose of, paying for the maintenance and repairs of those areas. But if that hasn't happened and there's necessary maintenance or repairs to an exclusive use area, the body corporate needs to arrange it, and then they need to collect that money from the owner concerned, because we don't want the rest of the owners unfairly subsidizing someone else's, exclusive use area when they actually have no right to use that area, despite the fact that it's common property. All right, Karina, if we can move to the next slide, please. Let's look at future development areas. So, many schemes are built in phases. And if we have a scheme where, say, for example, the first phase is finished, but the second phase has not been started yet, then we have an area of common property which the body corporate, because it's common property, the body corporate still needs to maintain. But because the developer has that future development right to extend the scheme and do it on that area, that developer is responsible to pay the body corporate's costs associated with the future development area. So there'll often be costs related to security, or even just, lawn mowing, those sorts of things. And the rest of the owners should not be paying for that because they're not benefiting from that area in any way. And so the developer is responsible for that under the SDSM Act. All right, Karine, if we can move to the next slide, please. Now we'll move on to utility charges. So there are obviously common property utility costs. So these are, for example, electricity for the common lighting, water for the common garden areas, gas if there's communal braai areas. And these costs are shared amongst owners based on their PQs and are recovered as part of the ordinary admin fund levies, unless obviously there's a Section 11.2 rule in place that provides for a different allocation method. Now, utilities supplied directly to individual sections or exclusive use areas are treated differently depending on the type of metering system in place. So we might have prepaid meters in a scheme. If they are prepaid meters for the sections and exclusive use areas, then the owners who are, the section owners and the section owners who benefit from the exclusive use areas, they will top up and pay for the electricity or water, directly to the service provider. And the body corporate isn't involved at all in the billing process in that case where there's prepaid meters. We might have a situation where there's individually metered supply to sections or exclusive use areas. So we have separate meters for each section or exclusive use area. And in that case, the body corporate must recover the costs from each owner based on the actual usage as recorded by the meter. So that'll be an additional charge on their, on their levy statement once a month. They will be charged for the actual usage. And then there might be a case where there's actually no meters for the individual sections or exclusive use areas. And if they are not separately metered, then the body corporate will recover the cost through the admin fund, just as any other body corporate costs. So it will generally be recovered based on participation quotas, but it may also have a rule adopted under Section 11.2, which changes the collection method. All right, and now we're going to move on to a big topic, which is the next slide, please, which is maintenance and repairs. And who is responsible for what in a sectional title scheme? And this is where I want you to think back to our foundational concept at the beginning of the webinar, where I explained that the nature of the property, as well as the SDSM Act and the body corporate rules, will determine who is financially responsible for it. That comes into play in a big way now. So let's start with sections. These are individually owned by the section owners, and so the SDSM Act makes the individual section owners responsible for the maintenance and repair of everything within the boundaries of their sections. But there is an exception to this, which is that the body corporate is responsible for pipes, wires, cables, and ducts that form part of a section, so they're within the section boundaries, but they actually are common, okay? So they either serve that section and another section, or maybe many sections, or they serve that section and the common property. So if there is a common pipe, wire, cable, or duct that is located within the boundaries of a section, the body corporate is responsible for that. So that's an exception to the general rule that an owner is responsible for the maintenance, repair of everything inside their section. So if there is a leak or some other defect in a pipe, wire, cable, or duct, which is located within the boundaries of a section, we need to ask the following question. Does the pipe, wire, cable, or duct only serve this section? And if the answer is yes, it only serves this section, then it's the section owner's responsibility under the legislation. If the answer is no, it's actually a common pipe, wire, cable, or duct, then it's the body corporate's responsibility because that pipe is serving other parts of the scheme as well as that section. So that's really important. And there's a lot of misunderstandings around pipes particularly. So the basic rule is that if there is a pipe that has a defect within a section, if that pipe only serves that section, it's the section owner's responsibility to fix. But if that pipe actually serves more than that section, maybe another section, maybe the common property, then it's the body corporate's responsibility. Okay, what about resultant damage to sections? This happens a lot, and I'm sure that Andrew and Karine and Peter will be well versed in this. So let's say, for example, there's a leak from the section above and it causes damage to a section below. Now, while the SDSM Act says that each section owner is responsible for maintaining and repairing their own section, if your section is damaged because of something that another person did or failed to do, then you may well have a legal claim against them. There's something called the law of delict, which is part of our common law. And what this says is that you can claim back the reasonable cost of fixing the damage to your section from the person who caused it through their actions, negligence, or failure to maintain. So, in the first instance, the Sectional Title Schemes Management Act says an owner is responsible to repair and maintain everything within the boundaries of their section. But if that damage to your section has been caused as a result of somebody else's negligence or somebody else's failure to maintain, you may well have a claim under the law of delict to recover the reasonable costs of repairing the damage to your section. All right, if we can move to the next slide, please. Let's look at unregulated common property. Now, remember that this is all the common property in the scheme that is not subject to exclusive use rights. Under the Sectional Title Schemes Management Act, the body corporate is responsible to maintain and pay for all the unregulated common property, and it funds that through the administrative fund. Okay, the administrative fund is there to cover the day-to-day costs of maintaining the unregulated common property, as well as all the other body corporate costs that are day-to-day management costs. And then there's also the reserve fund, which funds the maintenance, repair, and replacement of major capital items. And that is something that is based on the scheme's MR&R plan, or maintenance, reserve, and replacement plan. So the body corporate has funds which it recovers from the owners to fund all the necessary costs related to the unregulated common property. Now, there's an exception to this. Once again, we always have exceptions. There may be geysers located on the common property, and this is very, very common, where there's a geyser, it serves only one section, but it's located on the common property. So if that's the case, then the owner whose section is being served by the geyser must pay for that geyser. And if you have a common geyser, so for example, it serves multiple sections, then the costs of that geyser are shared pro rata by the relevant section owners. Okay, and again, looking at resultant damage, what happens, for example, if an owner crashes into the common gate on their way out, when they're driving their car? Now, because in the first instance, the body corporate is responsible to repair and maintain the common property, so the body corporate would be liable to repair that gate. But because somebody else caused the damage, they, under the law of delict, have a claim to recover the reasonable costs of repairing the damage from the person who caused it. Okay, let's move on to the next slide, please, which is pipes, wires, cables, and ducts. We've dealt with this a little bit under the liability for sections, but let's look at common pipes, wires, cables, and ducts. Any pipe, wire, cable, or duct that is on the common property, regardless of whether it serves multiple sections in the scheme or only one section, must be maintained by the body corporate. And there's a common misconception that we come across all the time, where people think that if a pipe, for example, is located on the common property, but it only serves one section, that the section owner will be responsible to repair and maintain that portion of the pipe that's located on the common property. It's kind of a user pays principle, right? Like if this pipe is only benefiting one section, then surely the section owner should pay for it. Under the legislation, that is not the case. So the body corporate is responsible for all pipes located on common property. As mentioned earlier, pipes, wires, cables, and ducts within a section that serve more than one section, or one section and the common property, those are also considered common, and they must be maintained by the body corporate. So again, this is an exception to the principle that a section owner pays for everything within their section boundaries. And just to recap, pipes, wires, cables, and ducts within a section that only serve that section must be maintained by the section owner. All right, let's move to the next slide, please, where we're looking at windows and doors in section boundary walls. So we know that a section's internal windows and doors, because they are within the boundaries of the section, must be maintained by the section owner under the STSM Act. Now, what about windows and doors that are located in the section boundary walls? So we know that the boundary between a section and the common property, as we saw with that diagram earlier with the dotted lines, is the median line, so the midpoint of the dividing wall, floor, ceiling. So this means that the inner half of that boundary wall of the section is part of the section, and the outer half of that boundary wall is part of the common property. So we call it the outer skin of the building. That little piece on the outside is actually common property. So who's responsible for the windows and doors that are located in these boundary walls? Now, essentially, we have a provision under the Sectional Titles Act, which says that the median line runs through windows and doors located in section boundary walls, regardless of where that window or door is actually situated within the wall. It doesn't matter if it's on the outside of the median line or on the inside of the median line or on the median line. If there is a window or door in a section boundary wall, the median line runs through it, which essentially means that windows and doors in section boundary walls are always half section and half common property. And what that means is that the costs of these windows must be shared 50-50. So again, I want to look at a Paddocks Club example where a member wrote, one of the window panes is cracked at a block we manage, and the owner wants the body corporate to pay for it. There's no indication of what caused the break. Who would you say is responsible? So the answer to this is if the cracked window is in a wall that is shown as a section boundary on the scheme sectional plan, which you'll see indicated by a solid line, then the median line will run through that window, okay? And the costs of replacing a broken window pane will be split 50-50 between the body corporate and the section owner. But remember the principles around resultant damage. In this case, they don't know what caused the break. But if it was obvious, for example, the section owner's son hit a ball into the window and that caused the window to crack, then the body corporate would have a claim against the owner for its 50% contribution of repairing that window pane. So essentially, the section owner would be responsible for 100% of the costs because it was through their son's actions that the window pane broke. So we need to think carefully when deciding, when it comes to windows and doors and section boundary walls, if it's, wear and tear, general maintenance, that sort of thing, it's 50-50. But if there is an obvious sort of a delictual claim there because it's from the owner or the occupier's conduct or negligence that it's broken or needs repair, then there will be a delictual claim and that person will be responsible for 100% of the costs. All right, let's move on to the next slide, please, where we're looking at balcony railings and balustrades. So who is responsible for these depends on the legal nature of the balcony. And this goes back to our foundational concept. Is the balcony part of a section? Is it an exclusive use area? Or is it unregulated common property? Now, if it's unregulated common property, which is less normal, but does happen, then it's easy. The body corporate is responsible because it's unregulated common property. Now, if it's an exclusive use area, then we need to check the boundaries of the exclusive use area. And we need to see if the balustrade is actually within the EUA boundaries, or if it's not. So if it is within the EUA boundaries, then the default position, as we mentioned earlier, is that the body corporate arranges the maintenance of that balustrade or railing, but then the owner who benefits from the exclusive use area is responsible to pay for it. Again, you always need to check the scheme's rules to see if the default position has been changed, which would make the section owner directly responsible for arranging and paying for that EUA maintenance, including the balustrade or railing. Now, if the balcony is part of the section, then who is responsible will depend on where the railing or the balustrade is bolted into the building in relation to the median line. So remember, the median line is the section's boundary. So we need to see, is this balustrade or railing actually within the section? Is it outside of the section on the common property, or is it on the median line? So if it's attached to the building within the median line, then it's part of the section, and then the section owner will be 100% responsible because it's part of their section. If it is bolted outside the median line, then it's attached to unregulated common property, and then the body corporate is 100% responsible. And if it's attached on the median line itself, then the costs will be shared 50-50 between the section owner and the body corporate because it's essentially half section and half unregulated common property. So those ones can get a little bit tricky in practice. All right, if we can move to the next slide, please. We're going to look at unauthorized improvements by owners. So what about building alterations or improvements made by section owners to the common property without body corporate consent? This happens all the time in practice. And we know that the body corporate is responsible to repair and maintain the common property, but does this actually extend to including maintenance and repairs for unauthorized alterations made to common property? And the answer to that is no, it doesn't. The body corporate should not take responsibility for unauthorized common property alterations or improvements. For example, as in this picture that you can see here, if an owner illegally extends their section by building onto the unregulated common property, and then later down the line, that area might start to leak, the owner might come to the body corporate and say, you need to fix this because it's on common property. Is the body corporate actually responsible for that? And the answer is no. The body corporate can deal with these unauthorized building alterations in one of two ways. The first way is to regularize it. So that means actually granting the required authorization for the building under the SDSM Act and to make it legal, okay? And if the body corporate goes this route, I always advise clients for the body corporate to attach maintenance conditions to its consent. So require the owner to take full responsibility for the maintenance and repair of that area. Now, the other way that the body corporate can deal with these types of illegal alterations is to force the section owner to remove it. And they can do that by making application to the CSOS for an order under section 392D, and that allows a CSOS adjudicator to order an owner to remove all items illegally attached to the common property and restore the common property to its previous state. Let's move on to the next slide, which is insurance excess and additional cover. Sorry, I know I'm throwing a lot at you, trying to get as much as we can into these 30 minutes. So if the body corporate's insurer pays out, we need to look at who's going to pay the excess, because there's generally excess to be paid on these types of claims. Now, if the insured event relates to an owner's section or exclusive use area or their geyser, then the section owner is responsible to pay the excess. If the insured event relates to unregulated common property, then the body corporate will pay the excess. And the prescribed management rules also allow a section owner to request that the body corporate increase the replacement value of their unit or exclusive use area. So, for example, an owner has done renovations internally to this section. They've installed beautiful German finishes, whatever the case is, and it's very expensive. They might want to get an increased replacement value for their unit. And if that's the case, then the owner will need to pay the body corporate for the increase in the body corporate's insurance premium. And then let's move on to the next slide, please, which is when things go wrong. So what if someone refuses to pay or to do the work that they are required to do? So levies, as I'm sure you all know, if there are levies owed to the body corporate can take action to recover the levies from the owner via either the CSOS or the magistrate's court. If there's maintenance and repairs to sections that need to be done and the owner concerned is refusing to do so, we have a provision in Prescribed Management Rule 31.2, which states that if an owner refuses to carry out necessary maintenance to their section and that failure threatens the stability of the common property, the safety of the building, or otherwise materially prejudices the interests of the body corporate, its members, or the occupiers of sections generally, the body corporate must remedy the owner's failure. So the body corporate must go and do the work to the section, and then it can recover the reasonable costs of doing so from the owner. The body corporate can also apply to the CSOS for relief. And there's an order under section 396B1, which allows an adjudicator to make an order requiring the relevant person to have specified repairs carried out. Now, if the problem is the body corporate failing to do maintenance or repairs to common property, then any person materially affected by the failure can apply to the CSOS for an order under section 396A for an order requiring the body corporate to have specific repairs and maintenance carried out. Now, what if someone pays and then needs to recover the costs? So, for example, when we spoke about the leak earlier from the section above to the section below, maybe the section owner below pays to repair the resultant damage inside their section that was caused by the leak from the section above, and the owner of the section above refuses to reimburse the owner below. In that case, the owner of the section below can apply to the CSOS, and they can get relief under section 396B2 of the CSOS Act, which allows an adjudicator to order reimbursement for repairs carried out in respect of the property by the applicant. All right, so last slide, just to move on to the conclusion. I know I've thrown a lot at you, and I'm sure we're going to get into it in the Q&A. But to summarize, especially when you're dealing with maintenance and repair responsibilities, always consult the sectional plan and the body corporate's rules in the case of rule-based exclusive use areas to determine the boundaries of these areas, because so often in practice, somebody is saying it's the body corporate's responsibility, and someone else, the body corporate, is saying it's the section owner's responsibility or the exclusive use area holder's responsibility. And we need to determine where are the boundaries of this particular area to see who is actually responsible for it. And we move then to the Sectional Title Schemes Management Act and the prescribed rules to look at what the default financial liability rules are. But again, we can't stop there because scheme rules can override those defaults. And so we need to double check the specific schemes rules. So thank you so much. I know that was a lot. I hope that brought some clarity to this all important question of who pays, and look forward to your questions.
Right. Thank you very much, Jennifer. I will kick off, and then I'll ask Karine to come in with any particular themes or recurring issues which she saw in the Q&A. So Jennifer, just some practical implications from what you're saying. I think mainly just to emphasize that all sectional title owners, I think, are encouraged to, number one, have copies of the sectional plans and the sort of approved conduct rules so they can familiarize themselves with the status of their sections, and if they've got garages or patios or gardens or storerooms, etc., to understand the designation of those areas, which really is the starting point to understand who maintains them, who pays for that maintenance, and what should happen if anything goes wrong to do that. And it's surprising how many people are not sure of the designation of the different areas, haven't been
Yeah.
informed through a sales process, or
Yes.
perhaps they've been misinformed as well. So it's a very good starting point just to clarify that and having those source documents. And anyway, those source documents are going to be crucial if there is a dispute lodged with the CSOS as well, isn't it?
Absolutely. And you've actually raised a really good point because there is no one size fits all when it comes to what type of property is a particular nature. So for example, you mentioned garages. Garages can be a section. They can be an exclusive use area. They can be unregulated common property that's leased to an owner. There are different ways of classifying these different areas in a scheme. And it really changes from scheme to scheme depending on how the developer set it up. So really, there is no one size fits all. And that's why it's so important when you are, managing a scheme or owning in a scheme to understand the different areas and what their legal nature is to determine who is responsible to pay for those areas.
Yeah. And, Jennifer, the other point is that, what we see practically a lot as managing agents is, trying to define the exact location or causality of a particular maintenance problem. So, for
Absolutely.
example, if there's a leak and it can be in the middle of a wall, it's not easy to see, what is the problem, exactly where is it coming from, and therefore to define who's responsible. So, just to
Yes.
emphasize the point that a qualified service provider would need to provide a detailed report
Yes.
of exactly what the issue is, where it is located, related to those boundaries you mentioned, and as
Yeah.
a point of departure in terms of the nature of the repair, number one, and then secondly, who is responsible for that repair, afterwards, which also means by implication, it's not certain when the work starts, what's going to be required and who is responsible for that particular cost.
Yes, absolutely. And then there's that other question of who even pays for the report, because if we don't know who's responsible for it, the section owner might say the body corporate should get the leak detection expert in, and the body corporate might say, well, this is your problem because you are the one with the, resultant damage, so you get the leak detector in. So, in those cases, I always recommend that if it's something that could be a body corporate problem, the body corporate pay for the leak detection expert on condition that if the report finds that it is actually something within the section, that the section owner then reimburse the body corporate for that cost. How do you deal with that in practice, Andrew?
Yeah, exactly that. So, if there's an impasse, then we always recommend the body corporate takes the initiative,
Yes.
organizes the specialist report, whether it's a leak detection or otherwise,
Yeah.
defining exactly what the nature of the issue is and the location. And that
Yeah.
forms a informed point of departure to proceed and get the necessary work done. Our
Yes.
next challenge, Jennifer, is, it can be quite technical, I think, as everyone's hearing today, and not all owners are wanting to understand or willing to cooperate in terms of their responsibilities,
Yes.
which naturally causes delay in terms of now escalating this as a dispute, trying to
Yeah.
persuade them, trying to get the trustees involved, trying to encourage them to be reasonable and legally compliant. And ultimately, as we know, if it needs to go to the CSOS, that is not a quick turnaround to get a binding order, to
Yeah.
get the owners to do the right thing, as it were.
Absolutely. And I mean, I've heard as of a day or two ago that many people are waiting over a year to get, an adjudication order from CSOS at the moment. So it's really, if you have an issue such as, a leak coming into your section and causing damage, and the section owner above is not taking responsibility for it, to wait a year, the damage is just going to get worse and worse. And so, yes, you can do sort of patchwork remedial stuff in the meantime, but if the cause of that is not resolved, then, it's a really difficult situation. So I wish there was a faster way of doing it, but unfortunately we have to follow the sort of legal channels.
Yeah. Okay, I'm coming to you now, Karine, but just my last comment, Jennifer, is just a practical experiential point is, I find that just getting people together on site makes a big difference, because you can get into the situation where there are lots of emails backwards and forwards. The trustees aren't necessarily on site or seeing what's going on. Property investors often live far away. They can't see what's going on in their unit. Agents might be involved. And just getting everyone or as many people as possible that are involved on site to look at the issue, see what's going on directly, it makes a big difference because, it often speaks for itself on site. The magnitude of the issue or the details of the issue become clearer in practice in person. And that seems to unlock, buy-in and progress and participation. So I find that, if there is complexity or uncertainty, just encouraging, a site meeting as quickly as possible and trying to bypass, just emails which don't really capture the whole scope of what's going on, it does make a difference.
Yeah,
All right,
that's
thank
really
you.
great. That's really great advice, Andrew. And I think, that's the practical side of like, how do you actually get traction and movement in something like this? Because as you say, these issues can drag on for months.
Yeah. Okay, Karine, over to you.
Thanks, Andrew. Jennifer, there's a question here on the Q&A where a unit's entrance has double doors. So there's an inner wooden door and an outer security door. Who will be responsible for maintenance on the outer security door? Where does the median line run in this case?
So actually, that's something that we didn't deal with in the webinar, but security doors, especially if they've been installed by the individual owners under the prescribed conduct rules, are actually for the section owner's account. So if these are security doors that have been installed by the individual owner, they will certainly be for the section owner's account. Now, if these are security doors that were installed by the developer, that's a slightly more complicated situation. We're talking about windows and doors and section boundary walls, the median line goes through it. But obviously, if you've got two doors, the median line can't go through both of them. And I've actually never come across this in practice. So this is a really interesting one. Andrew, have you ever come across this? Or Karine, have you?
I've just come across fighting about what authorization is needed to install the security doors because often they're on common property because they tend to be outside the door, outside the median line.
Yes, absolutely. So, in that case, I would say I can't see that both doors would be 50-50 because obviously the median line, there's only one median line. So we can't have a situation where the median line is going through both doors. So we would have to decide, where is the median line and then look at where the other door is in relation to that. If it's, the median line is going through the inner door, then the outer door would probably be common property. If the median line is going through the outer door, then the inner door would be part of the section. That's how I would look at it. But this is a super interesting one that I haven't come across in practice before. And yeah, I would need to look at if there's any sort of precedent on this, which I haven't seen. So a really interesting one.
Yeah. Then, Jennifer, in terms of exclusive use levies, so there was a question earlier with regards to exclusive use levies that should be used for maintenance of those areas. Do you know of any requirement in the sectional title legislation that those exclusive use levies must be ring fenced so that it's not used for other expenses and other like admin expenses or anything? And then is it also possible for the body corporate to increase the exclusive use levies if there's more maintenance needed, if the exclusive use levies corrected, even if they were ring fenced, are not adequate to pay for the maintenance?
Yeah, so that's a really good question. And I think, so it's the proviso to Section 31C of the Sectional Title Schemes Management Act says that the body corporate must charge an additional contribution to an owner who benefits from an exclusive use area to defray the costs associated with maintenance, repair, et cetera, et cetera. So the legislation doesn't go down to that granular level of detail and require ring fencing, unfortunately. Obviously, best practice and what we always encourage is that the exclusive use area levies are ring fenced for the particular exclusive use area. I don't know how practical that is. Once again, we spoke about this the other day, Karine and Andrew, the legislation versus the practice. ideally, you would be ring fencing those specific contributions to be applied to the specific exclusive use area for which they are collected. However, I know that that's not often the case in practice. So ideally, yes. Whether it actually happens in practice, I don't know. Now, in terms of the main thing is that no other owners should be subsidizing an exclusive use area that they don't have benefit to, right? So what we need to ensure is that whatever costs are required from the body corporate's perspective to maintain or repair that exclusive use area are recovered from the person who is benefiting from it. Hopefully the EUA contributions are enough, and if they're not, then the body corporate needs to recover the difference. Now, in terms of increasing the exclusive use area contributions, if there are increased costs, yes, absolutely. And, often we'll find, even in the example that I gave in the webinar, so the body corporate might be recovering a minimal exclusive use area levy once a month. Now, a big cost pops up in relation to the exclusive use area. The body corporate needs to recover the difference from the person who is holding the exclusive use right, because we can't have the other owners paying for this area which they have no benefit to or no right to use. So yes, and the way that this should work, according to the legislation, is that when the trustees do their annual budgeting cycle, obviously they have their budgets which relate to the admin fund and the reserve fund and how much they need for all the body corporate costs. But then we look at exclusive use areas as a separate sort of item. And the body corporate, the trustees, and, assisted by the managing agent, need to estimate what are the body corporate's estimated costs in relation to that specific exclusive use area, and then recover that over a period of 12 months from the owner. Because, a lot of schemes, I know they'll put a formula in place and just say, okay, it's this or that, but the costs that the body corporate will incur in relation to maintaining a parking bay might be very different to the costs incurred in maintaining a garden, for example. And so you can't just say, okay, it's a one size fits all. There's this sort of flat fee for exclusive use areas. What is the nature of the exclusive use area? What are the actual costs? And that is what the body corporate should be recovering.
Thank you. Peter, do you want to come in with any questions that have passed you?
Thanks, Andrew. I'll do a quick run through just what's currently on the Q&A. Jennifer, is there a formula to calculate EUA levy like the PQ calculation?
No, absolutely not. That's what I was just trying to say is they shouldn't be a formula. It should be the body corporate's anticipated costs in relation to the area. And so I think formulas are a little bit dangerous because they can sort of provide a one size fits all. And so, yes, I think it's more beneficial to actually look at the actual potential costs and then do it like that. Formulas can be unfair.
Of course. Okay, so also, whose responsibility is it to fix sewage pipes that are for a specific section, but those pipes only run to one specific section only? I'm guessing that these pipes are on the common property.
Yeah, so pipes on the common property are for the body corporate's account. Doesn't matter if they are only serving one section. As I said in the webinar, there's this misconception, this user pays sort of mindset where if this pipe that's running over common property is only serving one section and it only benefits one section, then that section owner should pay for it. And that's not the case. Under Section 31R of the SDSM Act, it says, all pipes on common property are for the body corporate's account. The only time that an owner is going to be responsible for paying for a pipe in a sectional title scheme is if that the defect in the pipe is within their section boundaries and that pipe only serves their section. It doesn't serve multiple sections or that section and the common property.
Excellent. One that falls rather into maintenance or what's allowed and what's not allowed. It seems like a unit owner has installed a security gate on the outside of their front door rather on the inside. And the trustees now have an issue with it. How would you deal with a situation like that?
Yeah, so I just want to actually look at the wording of the prescribed conduct rule that deals with these security doors. Give me 1 second.
Like you're referring back to the conduct rules.
Yeah, so let's see here. Where is it now? Sorry, I've got it in here somewhere, but basically what it says is that, oh yes, okay. So under prescribed conduct rule 4.2, an owner or occupier of a section must be considered to have the trustee's consent to install a locking or safety device to protect the section against intruders or a screen to prevent entry of animals or insects if the device or screen is soundly built and is consistent with a design, color, style, and materials approved in writing by the trustees. So we have this conduct rule which allows owners to install security doors, provided that they are consistent with the design, style, and color and materials which have been approved in writing by the trustees. So it sounds like the door in the question that you've raised is not, within the right style because the trustees have an issue with it. So in that case, the trustees would be, allowed to, or they could try and get that removed because it's an item that's illegally installed on common property, not in line with the rules of the STSMA. So they could go to the CSOS for that. There is an order that adjudicators can give to force owners to remove items illegally attached to common property. But in general, if the trustees have a sort of specification, and it's often in the conduct rules that says, these types of doors, security doors are allowed, they must be this color, this material, whatever, then owners can do it. And then they must maintain those doors themselves.
Thank you very much. And then a final one just for you on Paddock's books. If one has an older edition of the books and they don't want to necessarily go and update all of them, are there any new publications that are coming up?
So I think, and I mean, my dad, Graham, who's written all the books, will be the best one to ask about this. The books were updated in 2016 when the new legislation came into effect. So we have like ebooks and things like that are more sort of more recent. But if you're talking about the hard copy publications, if you've got the one from 2016, you're still good. But we do have, CSOS case books and template books and those sorts of things, which are ebooks, which are more recent. So if you don't have those, you can have a look at the Paddock's website for that.
Excellent. Thank you so much.
Thank
No
you.
problem.
Jennifer, we've got a few more minutes, so maybe just one or two more topics to bring up. So, talking about utilities. So as the cost of electricity and water has, dramatically increased over the years, the cost of recovering those utilities from different owners has become a bigger and bigger issue. So, two interesting scenarios. One, buildings that are supplied by Eskom, the fixed charges, that is the network and demand charge, and basically the connection charge, can be up to 47% of the actual bill, meaning that the consumption charges are half and the rest are fixed charges. So therefore, the manner in which the fixed charges is recovered from owners, is becoming a big deal, because if you don't recover the fixed charges, theoretically the body corporate is subsidizing 50%. And, it raises questions about, well, what is the fair mechanism to recover those fixed charges? Is it a pro rata fixed charge on the number of units, meaning if you're a unit and you've got a connection, you pay, the number of units divided by the fixed charges as a fixed fee because you benefit from that connection? Or should it be PQ based? And there's debates around that. So that's the one question. But linked to it, if a particular owner doesn't like the way that charge is being recovered, they disagree with it, how do they challenge it? Is it a body corporate resolution to change from one recovery mechanism to another? Or would you suggest rather that particular owner tests that recovery policy or principle through CSOS?
Yeah, that's a really great question. And I think, so there is basically the Section 11.2 rule is available. Basically, it's a rule that the body corporate can adopt by special resolution with the written consent of any adversely affected owners that allows the body corporate to recover a specific charge on a basis other than PQ. So in that case, the body corporate could decide to, split those fixed charges equally because they are actually, equal for each section owner, as opposed to recovering on PQ, because it doesn't matter if the floor area of a section is much bigger or much smaller, they're all paying the same amount. They all should be paying the same amount. That's fair, right? So the body corporate can do that. They need to follow the process of actually adopting a Section 11.2 rule, which, as I said, requires a special resolution, written consent of any adversely affected owner, and then obviously that rule needs to be approved by the CSOS before it can be enforced. So that's the one way of doing it. And if they are, and that's presuming there's no individual meters. If they are individual meters, then there is an argument under Prescribed Management Rule 29.3 that because the body corporate is required to recover the costs associated with the utility from the individual section owners, that fixed charge could be included in that cost. So yes, we have the meter reading, which needs to, form the basis of the charge that the body corporate imposes on the owner. But then there's also that fixed supply fee that should be added to that. So if there are individual meters, there's that argument. If there's no individual meters, I would say Section 11.2 rule would be the fair way to go. If an owner is feeling prejudiced by the way that their body corporate is recovering these fees, then they can go to the CSOS. There is an order that a CSOS adjudicator can make where an owner can challenge a contribution as unreasonable, or the way in which it has been raised is unreasonable. And so that's, I can't remember the exact section reference off the top of my head, but it's in Section 39 of the CSOS Act. So there's a few options there.
Thanks. And then just another interesting scenario, Jennifer. So all the schemes, in terms of the plumbing and reticulation, they might have separate supply lines into the bathroom, into the kitchen, into another bathroom, etc., which makes it challenging to install meters because, it's not one supply line. It's like a daisy chain situation.
Yes.
So those are typically the schemes that don't have water meters because the actual design and construction of the buildings at the time, water was, very inexpensive, and it wasn't envisaged that it needed to be measured and charged for directly. So there are those schemes that kind of either they break the charge up pro rata based on PQ, but you might then get a unit where there's one occupant and they feel prejudiced because now they're paying on a floor area, which, is a very different sort of basis than, another unit of the same size, which might have many more occupants. And, they might feel prejudiced then that the headcount approach, would be more fair. But that also has a management, implication in terms of tracking how many people are living there and, trying to understand when it changes. So I suppose, an interesting question is, can you differentiate? So if it's one unit, if it's one occupant or a small number of occupants, could they be charged differently to other units where PQ would be, appropriate based on standard occupation?
Yeah, so I mean, in that case, you would have to adopt a Section 11.2 rule. And as I'm sure everybody knows, like all sectional title rules have to be reasonable and they have to apply equally to all section owners. So this is, very unlikely to fly. I don't think that the CSOS would, if you are going to discriminate and make, certain owners pay based on certain things and other owners based on other things, you're going to have a very good reason for that discrimination. It's got to be justified as reasonable. And so I think it's going to be incredibly difficult to get something like that past the CSOS for approval. I don't know if you guys in practice have had any experiences like that, for example, and this is moving out of the utility space, but, if there is a scheme where there is a block of flats and the ground floor owners have gardens, but the other, first floor and up don't, there could be a rule in place that the ground floor owners are allowed to have dogs where the rest of the scheme isn't. And that kind of rule, you can sort of justify the discrimination because of the layout and the amenities associated with the sections. But something like this, where we're dealing with, payment of utilities, I feel it's going to be difficult, but I'd be interested to see what the CSOS had to say about a rule like that.
Just a slightly practical and technical question, Jennifer. So if there's, and there's obviously a lot of rain around the country at the moment, so we're getting reports of lots of leaking and resultant damage on a daily basis. So if there's a leak through a balcony or a window, and, take the example of the window as a 50-50 responsibility because it's built on the median line. Who pays the excess for resultant damage that, occurs inside a unit, that actually leaks through a window frame, for example?
That's a really good question. So I'm thinking, because obviously the costs associated with the window are 50-50, but now we're dealing with excess, and this is coming from, the claim is based on the section, right? That the section is experiencing damage. And so the insured event it relates to the section. So I would say in that case, the section owner would be responsible. But obviously when it comes to the cost of repairing the window, it would be a 50-50 situation. So I guess in that case, when the body corporate receives the insurance payout, you could say essentially that's 50-50 split in terms of how that should be split, but we don't want to give the money to each side. We want to just use the money to fix the window. So yeah, that's an interesting one.
And last question for tonight, Jennifer, have you come across examples where a particular owner doesn't like or can't afford an exclusive use levy and they want to relinquish the exclusive use rights because of affordability or other reasons related to the costs?
I haven't come across, an owner wanting to sort of cancel the exclusive use rights because of costs, but I have come across owners wanting to cancel the exclusive use areas for various reasons. And in that case, it depends on the nature of the exclusive use area. If it's a rule-based exclusive use area, we need to, change the rule. So that will, if it's a conduct rule, we need a special resolution for that. If it's if it's a management rule, you need unanimous resolution. Or if it's a registered exclusive use area, then you're going to need the written consent of the person who holds exclusive use rights. Any bondholder over that exclusive use area will need to give their consent. And then I think it's a special resolution under Section 5 to cancel a registered exclusive use area. So there's processes to cancel, but I haven't heard of people relinquishing the exclusive use rights purely based on cost. Is that something that you're coming across in practice?
I've seen a few cases, but it can happen where there's an objection to the pricing methodology of the exclusive use area or a major maintenance project, which could boost the costs, significantly, and people, mitigating their exposure to it in that particular way. But I think, as you said, there's a process to follow. There's a way of doing it correctly, and just starting with consulting with the trustees, is a good starting point to work with. Yeah. All right. Well, we are at 6 o'clock, so I would like to thank Jennifer very much for a very interesting presentation. Hopefully, everyone's learned something or had some interesting reminders tonight and interesting case studies. All of our contact details are on screen, so I think the offer is there. If there are any unanswered questions, anything crops up, any clarity required, please don't hesitate to reach out to any of us. We certainly will endeavor to get back to you pretty quickly. Thanks for the time. Thanks for attending, everyone. We appreciate it. The recording will go online, so it'll be there as a reference. We hope you join us next month again, and we hope you have a very good evening. Thank you.
Thank you, everyone.
Bye now.